Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Pro se, if you filed an employment discrimination lawsuit or intend to file an employment discrimination lawsuit and assert you sustained physical injury, pain and suffering, emotional distress as a result of the defendant's actions, you will have invited the defendant to ask for your patient physician medical records. Let's look at some reasons why pro se may want to file a motion to seal their medical records and the steps required to file the motion. I also want to preview the privilege doctrine. Remember, under Federal Rule Civil Procedure 26, parties may obtain discovery regarding any matter not privileged that is relevant to the claim or defense of any party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable matter. Relevant is key. And though relevant, medical records may still be privileged. In that case, party requesting the records is not entitled to the records. Or here's an example: medical record privilege. The doctor patient privilege, also known as the physician patient privilege, refers to a confidential communication between the doctor and the patient that receives protection from disclosure. Either a patient or a physician may assert physician patient privilege in the lawsuit. However, this privilege is one born of state statutes and is excluded from the federal rules of evidence. As such, the rules governing physician patient privilege may vary from state to state. The short answer is the individual asserting privilege must look at the state in which that lawsuit is filed. And one other thing I want to say about discovery: medical records sought through discovery typically are not discoverable where the non moving party does not place his or her medical condition at issue. For example, and we're going to see a case here where that happened. If the plaintiff does not or did not put his or her medical condition at issue in the lawsuit, the defendant could ask for the medical records in discovery, but the defendant is not entitled to them because the plaintiff did not put them at issue. In this case, where the defendant requests the medical records, plaintiff would object to the request on the ground it is not reasonably calculated to lead to admissible evidence, and is not reasonably calculated because, again, the plaintiff did not put his or her medical condition at issue. So now let's get to the discussion of sealing medical records. There is a standard that the person who is seeking to seal the records must show. The person seeking to get the records sealed must meet a standard, and that standard is called the compelling reasons standard. In other words, the person must show a compelling reason over the interests of the public's right to see those records. And there are four takeaways from this discussion that I want you to get. I want to introduce a case, Cranford versus Adams. Just give you background information on this case. The plaintiff sued for discrimination. He argued that his equal protection was violated. Specifically, as it relates to his violation, he argued that the nurse failed to apply medication to his skin, and she violated his equal protection rights. The defendant requested the plaintiff's medical records. So the question was whether the plaintiff's medical records should be sealed. The first takeaway is under the compelling reasons standard, a district court must weigh relevant factors, base its decision on a compelling reason, and articulate the factual basis for its ruling without relying on hypothesis or conjecture. In other words, there must be a real interest at stake here that would solidly lead the court to a decision without guessing or any apprehension. When it appears to the court that the seeking of the records is to be used illegally or improperly, such as use of records to gratify private spite or promote public scandal, to circulate libelous statements or release trade secrets, there are compelling reasons sufficient to outweigh the public's interest in disclosure. 3. The court, however, has made it clear that the mere fact that the production of records may lead to a litigant's embarrassment, incrimination, or exposure to further litigation will not, without more, compel the court to seal its records. In other words, the plaintiff must show that his or her interest outweighs the public's interest. And the fourth takeaway I'd like you to get from this is filings made under seal and how they work. You can find that at Federal Rule Civil Procedure 52D. The court may order that a filing be made under seal without redaction. The court may later unseal the filing or order the person who made the filing to file a redacted version for the public record. Subsection E concerns protective orders. For good cause, the court may, by order in a case, 1, require redaction of additional information or limit or prohibit a non-party's remote electronic access to a document filed with the court. So, how do you think the court ruled in this case? The court found that the plaintiff did not put his medical condition at issue because he asserted or argued that the nurse failed to apply medication to his skin. And 2, the court also found that the plaintiff's interest outweighed the public's right to access of the plaintiff's medical records. And I will leave a link where you can read the case, and it will be found at the bottom of the description page of this video. Okay? I hope this has been helpful to you. I'm Advocate Lucinda, your empowerment lawyer.